So good morning, everyone. I can see everyone chime in on the chat window. Welcome to today's session. So on the Not-for-Profit Act and what's new. Thank you for joining us. Before we start, I would like to acknowledge that the land we identify as RTO9 is the traditional territory of the Haudenosaunee, Anishinaabe, and Huron-Wendat peoples. RTO9 and the Indigenous Tourism Ontario honor and respect the land, the people, and the treaties. We are extremely thankful for the original tour guides of these lands and all that they have shared. All those that reside, work, and play on these lands are treaty people, and we must honor the treaties in a mutually beneficial and equitable manner. With 1 in 5 Indigenous people in Canada living in Ontario, we believe working together in a mutually beneficial manner will help all Ontarians prosper through the joint development of the tourism industry. Ontario is home to one of the largest Indigenous tourism industries in Canada. RTO9 and ITO are pleased to be working side by side together under an MOU to help advance the Indigenous tourism industry in Ontario. As an ally to Indigenous people and a partner of Indigenous Tourism Ontario, RTO9 will commit to improving the socioeconomic conditions of Indigenous people through tourism by creating space for Indigenous people to tell their stories on their terms. Now, I just want to touch on a couple of housekeeping notes before we get started this morning. First, this workshop is being recorded for all the attendees and will be available viewing after today's session. I will send a link through email. There is the option to ask some questions. I will be keeping an eye on the chat and the Q&A box for Rose during today's session. So if you have a question, feel free to pop it in. I'll make sure that it gets passed along. If you pop it into the Q&A box, as I mentioned, it can be done anonymously, or if you prefer, you can also pop it into the chat window. After today's session, you'll receive an email. So it will also include the recording and a copy of Rose's presentation today, as well as a 2-minute survey link. So if you're able to spare some time to review the webinar, that would be awesome. And now, without further ado, I'm going to pass it along to Rose to get started on today's session.
Okay, thank you very much, Meg. I'm very pleased to be here. So I'll give you a little quick background on myself. Rose Mercier is my name. I am a senior partner and consultant with the Governance Coach. We've done some work with RTO 9 on just governance basics and whatnot. And so when I was asked to do this, I was pleased to provide some, I guess, some ongoing or some information about the new act. So hopefully, I'm really pleased to see this many people here, because usually bylaws are not the most exciting topic in the world. But I think anytime there's a change in the law that regulates a group of organizations, the nonprofit sector in this instance, it is important. I know I am, my little caveat here, my disclaimer is I'm not a lawyer, but I have written and revised a lot of bylaws. A lot of that happened when the Canada Not-for-Profit Act also was revised. And so I think that, if you will, spurred on the reconsideration of not-for-profit acts in many of the provinces. And some of the changes are similar to those that were made with the Canadian law, and some of them are different, particularly in Ontario, as it respects members and ex officio members. There were quite some, I think, some important differences. The other thing I want to note is there are a lot of excellent resources. So if you're just looking to start the process of revision, I have some references at the end of this, but certainly Ontario Nonprofit Law website is an excellent site for good references that you can do, and they're free, so which is a great benefit. But lots of things available to help you out. So hopefully with this will give you get you started, or just reaffirm what you've already been doing. So what we're going to cover today is, so what was the rationale for introducing the act? What's different now if I'm a director of a board? The new category of nonprofit corporation and what it means. So that's the public benefit corporation. We'll talk about that. And then what membership organizations need to state in their bylaws. Okay. So why was this new act put into place? So one is that it really became a modern regulatory regime for nonprofit corporations in Ontario. The old act was very old, and also applied to business corporations as well at some point in time. And so there was just a lot of things that weren't applicable and also a bit old-fashioned. So what it did is it really enhanced corporate governance, the importance of transparency and accountability. It made the incorporation process way more efficient so that you can file electronically. You're not waiting for approval by some body. As soon as you've submitted it, you can be in business. It enhances the rights of members and clarifies the rights of members of organizations. It increases the protection for directors and officers, and this is, I think, a very important aspect of the new act. It also, as I've said, distinguishes between public benefit corporations and other nonprofit organizations. And finally, it simplifies review of a corporation's financial records. So you'll see the opportunity to not just have audits. We'll come to that anyway. So that's some of the rationale behind the act. So in terms of increasing the protection for directors, what ONCA does is it explicitly states standards of care, right? So it says that if you're a director of a corporation or an organization, you need to act honestly and good faith with a view to the interests of the organization. These are often along with the next one, which is that you need to exercise the care, diligence, and skill that a reasonably prudent person would exercise in comparable circumstances. I think the caveat here, with what you know, right, with your knowledge. This is often just shortened as fiduciary duties, but I think it's really important to understand what that actually means, right? So So one of the things that it also does is it includes, if you will, a reasonable due diligence defense, all right? So if directors are acting in good faith on financial information reports of officers or employees of the corporation, in certain circumstances, they can state that they actually have gotten good information, that in good faith, they trusted the information that they were given. The other thing that is important is, while it doesn't immunize directors from liability, it does allow your organization to indemnify, all right, directors and officers, former directors and officers and individuals, provided, right, that person acted honestly in good faith and in the view of the best interests of the organization. Or if a matter is criminal or it has an administrative proceeding attached that's enforced by a monetary penalty, it allows you to indemnify individuals if they had reasonable grounds for believing that the conduct was lawful. And that becomes important because what it allows organizations to do is to purchase insurance for the benefit of those for whom indemnification is available. So you often hear that talked about as D&O, or directors and officers insurance. Okay, so the other thing that ONCA did is to really clarify conflict of interest and to make that, if you will, clearer, allow for more transparency, more accountability. So it requires conflict of interest by disclosing, right, that you have a conflict of interest and refraining from voting in when you do have a conflict of interest. That's very similar to what is in the Ontario Business Corporations Act, right? It also recognizes conflict in circumstances where the director or officer has a material interest in any other person who is party to a material contract with a transaction. So in simplified language, if you have a marital partner and that person is perhaps looking to sign a contract with the organization of which you're a part or of which you're on the board, you are obligated to declare a conflict of interest, even though it's maybe not your company. not your contract, it's seen as a potential conflict of interest. So if you have a material interest in something, or if you're, let's say, a partial partner in a company that's submitting a bill to do some type of services, so you need to be on the be aware, if you will, of potential conflicts of interest. ONCA also, I think, provides the opportunity. So if all of the directors are conflicted, which is probably an extreme situation, and thus unable to vote on a proposed material contract or transaction, ONCA authorizes members to approve the matter. So you can put that before, if you wish, a general meeting, or as you'll see, there are other ways for members to vote, that they can vote by mail, etc. So, and the other thing that I think is a useful, not twist, but a useful provision in the Act is that if no quorum exists for the purpose of voting on a resolution to approve a contract due to the non-presence of conflicted directors, so directors with a conflict of interest have to leave, and therefore there's not a quorum of the board left, ONCA deems that the remaining directors constitute a quorum for the purposes of voting on the resolution. So I think those are some really helpful, as I said, helpful provisions in the area of conflict of interest. So ONCA did create a new category of nonprofit organization, which is called a public benefit corporation, which RTO 9 actually is, and your organization might be as well. So you are a public benefit corporation if you are a charity, or if you have received more than $10,000 in the previous financial year from public sources, which they include grants or similar financial aid from provincial, federal, or municipal government or agency of government, such as the Trillium Foundation. Gifts or donations from people or organizations who are not a member, director, officer, or employee of the nonprofit. So, for example, if you get more than $10,000 as a grant from the community foundation, for example, that would be part of a public source of data, of information. So the thing that grants or financial aid, just a clarification, is that they are subsidies, there could be loans, there could be amounts given to support your work, but it doesn't include fees for products or service. So if someone is buying something from you and you realize $10,000, that is not considered public source. Okay. All right. Oops. So there are some special rules for public benefits corporations about when they review and report their finances and what they can do with assets if they dissolve. They're pretty straightforward. PBCs that are not charities, all right, cannot have more than 1/3 of their directors, so their board, if you will, their board of directors. So directors gets used here in the sense of board members, but you cannot have more than 1/3 of your directors who are employees or ex officio directors. And we'll talk about what ex officio is in a moment. If you dissolve, all right, voluntarily or otherwise, you must distribute your assets to another public benefit corporation with similar goals, or a government agency or municipality. You cannot distribute those assets to your members. And a nonprofit organization that has not or has been a public benefit corporation in any of the previous 3 years, right, may still need to follow public benefit rules when distributing their assets. If you become a public benefit or corporation, if you will, in the course of a fiscal year, you then need to be thinking about that in the year ahead. So something also we talked about, what ONCA did is really clarify and support members' rights in organizations. And one of those is members' access to financial documents. So any member of your nonprofit can ask for a copy of your financial statement and your auditor's report if an audit was done. We'll come to circumstances when that might not be the case. They can ask for those at any time, and they must be provided access to those documents during regular business hours. they must be sent financial statements or a summary of them at least 5 days before your annual meeting. So we come to audit and review engagements. So one of the things that this clarifies, this table shows you, is that there are different rules for different annual revenue. So the annual revenue is where you're getting, more than $10,000 in public funds. So this is the annual revenue in terms of public funds. Is that as a public benefit organization, you can pass an extraordinary resolution that says you do not need to do an audit or a review engagement. All right. So you rely on financial statements, etc. The caveat to that is a funder may require you, even if you're only getting $9,000, to do an audit. Okay. If you're not a public benefit corporation, you can also pass an extraordinary resolution that says you don't need to do an audit or review engagement. So in the case of financial matters, the extraordinary resolution, what ONCA requires is that at least 80% of members who vote in AGM must vote in favor of that resolution. So often hear talk of ordinary resolutions, which are simple majorities. Extraordinary resolution in many cases is more than 3/4, but in this case, it's you need at least 80% of members who vote in favor of a resolution, or right, all of your members need to agree to it in writing, right? Which is another way. If you don't have a general meeting, but you in fact have all of your members agree to the resolution in writing, then you can that resolution would pass. The other thing here is that every extraordinary resolution has to be voted on once a year. So while you might agree in year one that you're not going to do an audit or review engagement, you need to, that isn't, that resolution doesn't hold for the end until the end of time. You actually have to put that resolution to the members every year. If you're receiving between 100 and 500, $499,999.99 to be precise, is you can still pass an ordinary resolution if you're a public benefit corporation that you will have a review engagement, and we're going to define what that is. It's on the next slide, I think. If you're not a public benefit corporation, then you can pass an extraordinary resolution that says you don't need to do an audit and review engagement. And over 500,000, you can you must have an audit for. If you're not a public benefit corporation, once again, you can pass an extraordinary resolution to have a review engagement. So I'm seeing Meg. This must mean there's a question.
Yes, there is a question.
Okay.
The question is, does the 80% vote also need to be in writing?
No.
Does in writing apply to both?
No. So the difference here is if you're at a general meeting or a members meeting, 80% of members who vote must vote in favor. That you can put your hand up. So typically it's a hand up unless a ballot is required by somebody. If you're doing it but in writing, you need to have all of your members need to agree to it in writing. So the bar is higher.
Thank you so much, Rose.
Okay. So we'll just look at the definitions. So extraordinary resolution. An audit, I think pretty simple, is a certified public accountant who's independent of your organization, checks your financial records, financial position, ensures that you're in fact observing the standards of generally accepted accounting practices, etc. You've probably all seen an auditor. A financial review engagement is also done by a certified public accountant, independent of your organization. It takes less time and it's less expensive. So it gives you some options. So, and Meg is back.
You have some more questions.
Oh dear. Okay.
One is asking about between 10K and 100K revenue sources.
Mm-hmm.
What sort of voting structure do you need for organizations to have that, I guess, smaller budget?
I'm not sure I understand that. I don't think there's any particular voting structure. I mean, your bylaws are going to specify what your voting structure is, right? And it's typically one member, one vote, unless your bylaws determine otherwise. We're going to cover that voting or membership rights in when we get to a bit further on, but
Perfect, because that was our next question is also a nonprofit organization, all volunteers.
Mhm.
With goals to promote and encourage social, recreational, cultural betterment of the community, but their income is less than $10,000 a year. And other than a bank account, they have no assets, so
Yeah,
does it
they
apply?
don't need to do either. They don't need to do an audit or a public, right? They can just pass it. They still should be passing a resolution that says we are not doing an audit or a public review. We look at our bank account and we carry on.
Perfect, thanks so much, Rose.
Okay. So something I just want to talk about too, in terms of hierarchy of the authority of documents, and this is useful because as we go through, when we're looking at what your bylaws need to state, it'll often say your bylaws can state this, but it can't contradict the act. And so what you need to know is that the highest authority of documents is always legislation or regulation. In this case, the Ontario Not-for-Profit Corporations Act, which I just call ONCA now. Articles, which are your, if you will, your incorporating documents, all right, which are separate and different from your bylaws. But your bylaws cannot contradict your articles, and they cannot contradict ONCA, and your articles of incorporation cannot contradict the act. All right. So you can't say, well, we don't like that, we're going to write something different. Yeah, no. Okay. And you're back.
I'm back. I'm jumping in before you move on. The
Mhm.
next question is just, is the new Non-for-Profit Act for Ontario similar or designed based on the Canadian Not-for-Profit Act?
It is similar in that it increased the rights of members. Some of the things that are different related to, for example, in the Canadian Non-for-Profit Act, your board of directors cannot include ex officio directors, which are individuals who become a member of the board as a result of a position that they hold outside the organization. So very typical in national not-for-profits was that they would have boards that were comprised of the president of each of the provinces and territories, and they would sit on the board. So that composition of a board was no longer possible. So,
Perfect.
yeah.
And I have another question that's, if they're established under AHOA, is that above the Ontario non?
Oh dear, AAOJ. I need some help with the
I would
acronyms.
say, I also need some help with the acronyms. I'm not sure what the AHOA is. Um,
Association of Hospital Organizations? No?
I am,
Yeah,
I'll come back to it, Bob, if you're able to
okay.
elaborate on what okay, Agricultural Horticultural Organization Act. So it's
No,
agriculture.
yeah, you're incorporated under a different act.
Okay, perfect.
Yeah.
So ONCA is not
Yes, yeah.
applicable.
Now, the other thing that I would also say to this is that that's my understanding, and if you have any questions, I would say it's probably useful to double check with your lawyer, but if you're incorporated under one act, you're not incorporating under another act.
Perfect. Thank
Yeah.
you, Rose.
Okay. All right. Phew. So here's what your bylaws need to state about a variety of things. So when it comes to organizational purpose, this needs to be stated in your articles, right? So when you've submitted for incorporation, it usually says, here's the organization is incorporated to do these things, all right? You do not need to restate those in your bylaws. You can if you choose to, but I always say that one of the things that I think is a guideline for myself is to try not to have the same thing stated in 3 places. So if it's in the act, well, sometimes articles, you need to put things into your articles that the act says you need to put into them, but you don't necessarily need to put them into your bylaws as well. And part of that is if you change one, you got to remember that it needs to go back and remember the hierarchy of those. So it's just trying to, I think, keep it as straightforward as possible in order to to operate. So, however, if there's any restrictions, right, on the organization's activities or powers, those must be also stated in your articles, right? You can't just state them in your bylaws. They need to be in your articles of incorporation. Okay, so this is about admission of members, right? Is if in addition, all right, to individuals, all right, so individuals can be members, but if other legal entities or other corporations can also be members of your organization, you need to make sure that those are stated in your bylaws. You also need to state if ex officio members are permitted. So this is the notion of somebody it has a position in another organization, that they are also a member of your organization. They're called an ex officio member. You need to ensure that that's stated in your bylaws. And then you also need to state in your bylaws, what are the conditions required for membership? So does it require board approval? Does it need a, submission of a something or completion of an application, or do they need to be recognized? Whatever, if there is something, if there is a condition attached to being a member other than just I pay my fees, you need to ensure that that's recorded or stated in your bylaws. There's a question.
There is a question. So if an organization is federally incorporated, they should be following the Canadian
Canada, absolutely.
federal and not the Ontario.
Correct. Yes.
Perfect. Thank you,
Yeah.
Rose.
Yeah. Okay, so the other thing that you want to state in your bylaws is if there is more than one class of member, right? So let's just think of an example. So it might be, well, let's just pretend you've got you're an RTO, and I'm making this up. So excuse me if you might have, tourist organizations as one class of member, and then you might have individuals as another class of member. And so you might say, people who are supporters, etc., they can join as individual members, but you have other organizations that start. So you might say we in fact have two classes of members. So if you have more than one class, you need to state that. You also need to state for that, what is the conditions for membership? How do they withdraw or transfer to another class if that's possible, and how membership ends, right? So just some things to keep in mind if you're thinking about, okay, we have two classes of members. How do they become members? How do they, what happens if they want to become another class of member? How does that happen? What are the conditions related to that? Okay, you need to state in your articles, so not your bylaws, but how any restriction, if you will, does not to be stated in your bylaws, but how is membership, when does it expire, what happens when someone resigns, how is membership terminated, should be in your articles. You can restate it in your bylaws, but once again, try not to, if you will, duplicate or contradict, if you will. And then also any restrictions, I think we've said that. I'm just looking at this. This might be, I think I might have not copied this into it. It says this actually needs to be in your bylaws, how members can resign, expire, or terminate. Okay, I apologize for that. I am copied and pasted. So I will change that and send you I'll send you a new PDF, Meg, so it includes the corrected version of that. So in transfer of membership, the ONCA default is that membership transfers back to your organization, doesn't transfer to somebody else. If your membership can be transferred in any other way, then you need to put that into your bylaws. So fees, often a contentious discussion in membership organizations. Your bylaws may state a rule about fees if it is something other than the board of directors setting annual fees and deciding on the amount. Okay, if they're set in any other way, then that needs to be in your bylaws. If you don't say anything about fees, then in fact, ONCA is the, if you will, the appropriate reference. Okay, so this is about member meetings, right? These next sections here. Annual meeting or calling of meetings, you probably require this. ONCA requires an AGM 18 months after incorporation. I suspect many of you are ongoing organizations. An AGM needs to be not later than 15 months after the last AGM. This is pretty unusual. I mean, most nonprofits I know have a pretty standard date and time for their annual meeting, and it happens in June or May or January or whatever of every year. There may be, excuse me, I'm just going to mute for 1 second here. There may be extenuating circumstances when, in fact, you need to delay your annual meeting by a couple of months. So ONCA allows directors to call a special general meeting at any time. So a special general meeting is a meeting of members that happens outside of your annual general meeting. You can restate these rules in your bylaws, but you do not need to. So members' requests for meetings. So the ONCA, what ONCA says is that members with at least 10% of the votes, right, must send a request to each director and to the organization's registered office and request that a members' general meeting be held. Okay. You can in your bylaws, if you require less than 10% to request a vote, you can put that in your bylaws. You cannot make it more than 10%. All right, so it's at least 10%. You could say at least 5% as you choose. But if it isn't in your bylaws, then the act prevails and says that you must have, if 10% of your members want to hold a general meeting, right, on anything, they need to send that request to each of the directors of the board and to the organization's registered office. So this is one of the areas I think that is, if you will, an additional sort of members' rights that were provided for in ONCA. And that's that sort of, if you will, that increase in provision for members' rights was something that you also saw in the Canada Not-for-Profit Act. So notice of members' meetings. ONCA requires that each member is entitled to notice. Each director and each auditor or person appointed to conduct financial review must receive notice not more than 50 days and not less than 10 days in advance. So if you're having an annual meeting or a general meeting, you need to be providing that type of notice. You also, it also requires that any member proposal, right? So a member submits a proposal to be voted on or to be considered by the general meeting or the purpose of the general meeting, that that member proposal needs to be included with the notice. The default, unless you state otherwise, is the cost of including that proposal must be paid by the member submitting the proposal. And your bylaws or a resolution, all right? So you can, in fact, submit if you will, a motion to the general meeting that says something other than the cost of including the proposal has to be paid by the members. And then bylaws, all right? So any additional notice requirement with respect to what's the content, the form, the method of notice, etc. So anything else that you want to require in terms of notice of meetings, you can include in your bylaws.
Hi, Rose, you do have a question. Is the requirement for notice also for regular board meetings, or are they just for
No, this is we're talking just about member meetings, right? So general membership, annual general meetings. So we're going to come to boards of directors meetings. Maybe only if we can switch the slide. Okay. All right. So we are still on members meetings here. Place of your meeting. So the meeting must be held in Ontario at a place stated in the bylaws, unless the articles state otherwise, right? Or all voting members agree otherwise. Okay, so if I'm not sure if this lets you go to Las Vegas for a meeting or not, but I think in which case, probably not. Well, I mean, it might be possible, but don't take my word for that. If bylaws do not specify the location, the directors can decide. So if it doesn't say in your bylaws that the annual general meeting of your organization will be held in Kingston at, a date and time to be determined by the directors, then a date, time, and place to be, well, no, if your bylaws say it's going to be held in Kingston, the directors don't have any location. If the bylaws simply say the annual meeting will take place at a time and location specified by the directors, then the directors or board of directors, right, are decide that location. And the other thing about place of meetings is that anybody who is entitled to attend the general a members meeting can participate through telephonic or electronic means if the organization makes, oh, that's interesting, means available, not means available, means available. So not, some of my editor isn't working today. Anyway, the bylaws need to state that meetings can be held entirely by telephonic or electronic means. So if you hold an annual general meeting and you're saying they could be in place, but we actually would also enable our members' meetings to be held entirely by, telephonic, mostly it's electronic these days, then you need to put that in your bylaws. Also, your bylaws need to state, so the ONCA default, right, is that 50% is quorum. If quorum is something other than 50% of the voting members present in person, by proxy, or by telephonic or electronic means, bylaws, your bylaws need to say that. They can permit less than 50%, but not more than 50%. So you can't say, a quorum for our organization is 80% of members, it's 50% is the default. You can say it's 30% if you choose. So the ONCA default is that the members' meeting can proceed if there is a quorum at the start, even if the quorum is not present throughout. So you have, let's say you have, 50% of your members, but 5 or 6 of them need to leave early to do something, you still can proceed with your meeting. And then the other ONCA rule is that if there is not a quorum at the opening of your meeting, the present members may adjourn the meeting to a fixed time and place, but cannot decide to do any other business. So you can, in fact, have a motion to say, let's adjourn the meeting to, Tuesday at this place, but you can't say, well, maybe we'll just clean up some of the other simple things on the agenda. Yeah, no, you can't do that. Proxies. So proxy is that every voting member is entitled to appoint a proxy. Only if it's permitted in the articles, right? Your bylaws can restate that, but a proxy need not be a member, all right, unless it's required by your articles or your bylaws. So this is often I think a contentious point in membership organizations is saying is the proxy needs to be carried by another member. So if that's the case, you need to make sure that that's written in your bylaws. Otherwise, any person can carry a proxy for another member and use it, with the full, if you will, the full authority that member is entitled to. So the proxy must be signed either by the member's attorney, or the office or attorney of the body corporate. So if the proxy is being carried for an organization, it needs to be signed by an officer of that corporation or the attorney for that corporation.
I have a question about proxies, Rose. And if they're completed, like a completed proxy, does it need to be kept for a minimum period of time?
That's a good question. I do not know the answer to that. So
thank you.
Check that out, but I'm not sure that I've ever heard that. I think you can record the proxies in your minutes, right? Like, so members were present and then proxies for the following people.
Perfect. Thanks, Rose.
Yeah. Okay, the last piece is about members' meetings. So the default, right, in the act is that every member is entitled to one vote unless bylaws state otherwise. So bylaws, I've worked with a lot of national sport organizations, all right, and so they will have different classes of members, and different classes of members will be entitled to different numbers of votes. And so that always needed to be really clarified in bylaws. This is true, for example, for organizations that are federations, where you're an organization made up of organizations, and sometimes different size organizations will have different numbers of votes. So if that's the case, then you need to make sure that that's recorded, that's stated in your bylaws. Otherwise, the default is that one member, one vote. Okay. ONCA default again is that voting is by a show of hands unless a member demands a ballot. And that demand can be made either before or after the vote is taken. And so that's the default. If it's something different, right, then your bylaws need to state otherwise. So if all votes at your annual meeting are done by secret ballot, you need to make sure that that's in your bylaws. So bylaws can allow meeting before a meeting, all right? So you have an important thing and you want to make sure that everybody is voting. So you can, in fact, provide for members to vote by mail or telephone or electric before a meeting, but only, right? Only if you can verify that the votes were made by voting members and that you cannot see how each member voted. So that's a pretty high bar, actually, for cases where you want members to vote before a members' meeting. So adjournment of members' meetings. So you do not need to give notice if a meeting is adjourned, right? You do not need to give notice of the continuation of that meeting unless that adjournment exceeds 30 days, all right? So if you have a meeting and you say, it's too late, we're going to adjourn until tomorrow, you don't need to then send out notice again, all right? But if you're adjourning until, 60 days from now, then in fact, you need to send out notice. And the provision again is if your bylaw states something other than that, all right, then you need to make sure that they're in the bylaws. So the rule in the ONCA default rule is if members' meetings are adjourned several times for a total of more than 30 days, then you need to give notice of continuation of the meeting. So if you adjourn, you come back, you don't have enough people, you adjourn again, you come back, etc. And once that gets past the 30 days, that's what that means, is that you need to give notice of continuation. Otherwise, that's not necessary. So you'll see in the, I should have pointed this out, is that under each of these, you'll see section 48.6, section 58, section 67. These are the references in the actual act itself. So if you want more detail, I always say, go to the source and read what's in the act. It's long, but it's pretty, if you have where you go, it's easy to manipulate and work through. All right, so this is about boards of directors. So this, the fallback rule, and I think you'll describe qualifications, but usually these are pretty straightforward. It's like you have to be over 18, you can't be bank or in state, you can't be bankrupt, you can't be in prison, etc. So there's some pretty standard things. You can restate these in your bylaws if you want, you just can't, once again, contradict them. And similar with members on a board is if your board, all right, if the directors, your bylaws need to say if directors must be members or if there are ex officio directors on your board. So ex officio again is that someone is a member of your board because they hold another position. So they might be president of another organization. So similar as I talked about if you're a provincial organization and you have members in different regions and the regional associations president sits on the board, then you need to make sure that you say that. They're called ex officio directors, and there are particular rules related to that. Okay, so electing and re-electing. Once again, your bylaws can restate this, but they cannot contradict that members must elect directors as needed by ordinary resolution, which is essentially a majority vote, all right? There is no limit in ONCA. Well, I'm going to fix up a few of these typos. No limit on the number of times that a director can be re-elected unless the bylaws state otherwise, all right? So organizations often, not often, some organizations are concerned about, kind of having new thinking coming through, and that they don't want to have directors who are re-elected and re-elected and re-elected for forever, that they actually set term limits. So, 2 terms of 4 years, or 4 terms of 2 years, or 3 of whatever you want. But I think increasingly I see directors or organizations being concerned about setting terms, but also setting a limit on the number of terms. I mean, we won't go into this today, but there's certainly arguments for and against that approach. Okay, so the ONCA rule for terms of directors, if the maximum term is 4 years, so you can't elect someone for a term of 10, you can elect them for up to 4 years. Bylaws need to state the term length, and or state if there are different or rotating terms for each director. So for example, if half of your board is elected in 1 year and the other half is elected another year, your bylaws need to specify that. They need to specify, the term length of directors when they're elected. And just if there's any, if they're not all elected in the same year, they need to say, how does that rotation work? And if the director is not elected for a stated term, right, so the term isn't precise, then the term ends at the following annual general meeting. So if someone is elected for, a term to fill in for somebody, the term usually ends at the next AGM, or there isn't a specific term. If the terms aren't specified, then the term ends following the AGM. So they'd be elected essentially for 1-year terms. Yes, Meg.
Yes, Rose, I have another question. So,
Okay.
would a board member be considered ex officio if they're appointed by a municipality?
Yeah, this is a good question. I don't think so. Well, not typically. So what your bylaws would probably set out is that if there are members elected and there are members appointed, and then ex officio are usually where there's a specific position, all right? So if, for example, your bylaws had that the mayor of the municipality sat on your board, that would be ex officio, right? Or the president of another organization of which is a part sits on your board. So it's that specific position, not where it's just a publicly appointed, right? A publicly appointed director. Yeah.
Perfect.
It's usually, yeah, bylaws just say we have X members elected and X members appointed by.
Perfect. Thank you. Other questions?
Yeah, but
Yeah.
sorry. However, they will be subject likely to different laws. For example, you might be in a position where so members can actually vote recall not vote recall, but essentially can hold a general meeting to get rid of a director. They likely cannot do that to get hold of publicly appointed. No, I know they can't do that to get rid of publicly appointed members.
And I have another question about ex officio, and is
Yeah.
that position a non-voting position?
No. No, I think it's been a bit of a confusing term that's often used to think about it as like our CEO is ex officio. Well, yeah, not really. What it means is if you're an ex officio director, you're on the board as a result of the position that you're on. You could be ex officio if you're a CEO. The thing is that ex officio directors are held to the same standard as every other board member, right? And have the same rights and privileges as every other board member. If you're, I mean, I suppose I'd have to read the act again more closely. If you can appoint ex officio non-voting directors, and going like, what is the point of that? Right? Like that's just asking for advice. Okay, well, you can ask for advice without them being on your board, right? So.
Perfect.
Yeah.
Thank you, Rose.
Okay, okay, so some more directors. So here we go. Is that removal of directors is what I was talking about. Is that, yes, is members may vote to remove members by a majority vote, right, at a special general meeting, usually called for that purpose, but you cannot remove ex officio directors. It's a really good question. I'm going to look at this, whether public appointments would be considered to be ex officio or something else. So I'll check that out and put that into the final part of this that I send out or send back to you, Meg. So, okay. If there are different classes of members, right? If you have a class of individuals and a class of organizations, the director elected by a member class, so sometimes you'll have a board where directors are elected specifically from a member class to the board, they can only be removed by a majority vote of that class. All right. So I'm trying to think of a good example locally. So a lot of my work has been done nationally. So I'll just talk about that. Is that, for example, many national sport organizations have a class of members that basically are their national team athletes. National team athletes have the right to elect a director to the board, and only they can also remove that director from the board. So you'd have to just translate that into your own situation, but it is the general membership can't remove a director who's been elected by a specific class of members. And then unless you state otherwise, directors are entitled to give reasons for why they shouldn't be removed. Okay. Okay, vacancies. As long as a quorum exists, the board can fill a vacancy. So this is a quorum on the board, right? So as long as the whole board hasn't suddenly resigned and there's only one director left, because that director made everybody crazy and everybody else left, that person can't then appoint all the rest of the members to fill the vacancy. All right. So, but as long as there's a quorum on the board, and the quorum, well, here we go, is in the next thing, is that the quorum is the majority of the fixed number of directors required. You can, in your bylaws, set a quorum that is more or less than the majority of directors. All right, so you can have a quorum, you have 9 directors, you can determine that quorum is 4 or 3 in order to carry on business. I mean, all of this is, for me, is always depends on context as to what a reasonable quorum is for the directors. But as long as you have a quorum where there's a vacancy, boards can fill that vacancy. And bylaws will may state that only members can fill the vacancy. Okay, spelt wrong. My goodness. So what that's saying is that if there is a vacancy on the board, that the directors, even if there's a quorum, the directors can't fill that vacancy, only members can do that. Excuse me, I'm going to cough. It's explaining to Meg, I have dry weather induced coughing. It's not, and probably doesn't help when you decide you're going to talk for a whole long time. Okay. So next, continuing on with boards of directors. So time and place of meeting. The default is that directors may meet at any place set out in the bylaws, unless the bylaws state otherwise. Okay. Bylaws notice of meetings. So your bylaws may state notice of requirements for board meetings, or they may not have any notice requirements, and there is no default. So you can just simply decide as a board that you're meeting every month, or your next meeting will be 6 weeks from now. You don't need to send out notice for that meeting if your bylaws are silent on that, or your bylaws may if you will, state that no notice is required for board meetings. The board meetings can determine the time and place they're going to meet. Electronic meetings, so same thing is the default is that directors can participate in meetings by electronic means if all directors consent, unless your bylaws state otherwise. So you could, directors can participate in meetings if the majority of directors consent, or if that's made available or made possible, or you can meet fully by electronic means, which you're also allowed to do. So, also with respect to directors' meetings, so the manner of voting, bylaws can state any procedure about voting in board meetings that you choose. So whatever you want is that, motions will be, resolutions will be considered by the board, and a majority vote will be held, or, regular vote will be held, or the majority vote will stand for all things except maybe something else that you want to ensure that there's a higher standard. You can, whatever that is, you can specify in terms of how your voting is done. Our voting is done by a show of hands, or and it may be that you make it possible for a director to require a balloted vote. Okay, so resolutions, and this is I think what ONCA provides for, which I think has been really useful, is that a resolution, all right, so that's a motion, a resolution that's signed by all directors or a committee of directors is equally valid as if it were passed at a board committee meeting. So sometimes there is a resolution that's required of a board in between board meetings, and so what you'll do is you'll set out that motion and ensure that each of the members gets a copy of that, and then sign that meeting. And you need to be, I think, clear if their electronic signatures are permitted, or it needs to be in writing signatures, etc. But you can, I think, make that more precise in your bylaws. But the resolution is if everybody agrees to that, or signs off on all of that, it is the same as if you have had a board or committee meeting. You can also pass written resolutions instead of holding a meeting. So I think that's what that's saying. Okay, so powers and responsibilities. So the ONCA gives the organization and its directors all the rights, powers, and privileges of a natural person, and states that your bylaws do not have to give these. Your bylaws may state your bylaws do not have to give these to your directors. All right, so the and I'm not 100% clear on this. I sort of know what this is, so don't ask me questions about natural person, but it means basically that you're you can vote, you can make decisions, you can take actions as an ordinary person, or the corporation can take actions as if it were an individual. Okay, bylaws can impose some specific responsibilities. For example, meet not less than once per month. And if you want to, I think we've already said this, if you want to restrict what the organization's activities or powers or authorities are, you need to put those in your articles of incorporation. And finally, with respect to remuneration, bylaws or articles can specify any limitations or restrictions on directors' decisions about payment of directors for their service. So many bylaws I read say that directors will serve without remuneration. Okie dokie. So next we're on to officers. So there is a good section 1 under definitions. There is a definition of officer, which essentially is that a person who is acting for the organization, such as the president, the vice president, the finance person, etc. So it's what those officers are: secretary, treasurer, etc. You can change those definitions in your bylaws if you choose to. You can determine that you're appointing, you'll appoint a board chair and other officers as necessary, or you will appoint, you will appoint a director as a chair, and you will also appoint a secretary and a treasurer. You can also say that those positions may be held by officers, or those positions can be held by individuals who are not directors. So, and an individual may hold 2 or more offices. I see this most frequently in organizations with, executive directors or CEOs, where the board appoints that person as the treasurer and secretary because they're essentially doing that work anyway. They may still appoint a vice president, but the election is that boards must appoint a director to be the board chair. Just to remember, and then also bylaws can state any rules or requirements about the removal or resignation of officers. I always think that's really helpful to know. I'm going to be chair until majority of it, maybe the majority of members are appointing somebody else. Or what you do in the case when somebody resigns from the office. Okay. So in terms of duties of different officers, there are some general officers' duties as they're described in the Act. They are pretty brief. Your bylaws can include a more specific direction or a more specific description of what, let's say you have a treasurer or vice president of finance, is what their role is and what their responsibilities are. You can put those into your bylaws. And indemnification, we've actually covered this before, is that, but I think it's a good thing to remind ourselves, is that ONCA does allow organizations to indemnify directors and officers, as long as they act honestly and in good faith and in the best interest of the organization, and believe their organizations are lawful and that it's possible for organizations to purchase insurance for this purpose. So your bylaws may state your position on indemnification and insurance, but they do not need to. Conflicts of interest. So same thing, is that there are detailed rules about directors and officers must deal with how they must deal with conflicts of interest, and it's very similar to the importance of declaring and removing yourself from votes on that. Bylaws, once again, you don't need to restate them, but you can't contradict it. So there are some things, this is all about duties of the board. So ONCA allows you to, says directors can create committees. Bylaws don't need to restate that rule, but you can if you want. And you can also specify, for example, if there are standing committees. So if you have a standing, audit committee, or if you have a standing governance committee, or if you're standing, I'm just trying to think of other policy committee or whatever. So if you have standing committees, you probably want to put those out in the bylaws. The thing that ONCA is clear about is that the board cannot delegate to the committee the power to submit to members questions or resolutions. So a committee can't, independent of the board, say this is a question that we want to be considered by members. Committees should not be making decisions that the full board should be making, in my way of thinking anyway. Committees, so the board cannot delegate to a committee the power to fill a vacancy on the board, right? Cannot delegate to the committee to fill the position of auditor or the person appointed to review engagement. So even if you have an audit committee, the decision of appointing the auditor belongs to the board as a whole. And you cannot delegate to committees the power to appoint additional directors, right? You can't delegate to committees that they can issue debt obligations unless authorized by the board, approve financial statements, adopt, amend, or repeal bylaws. They cannot delegate to committee the power to establish contributions or to be made by fees or paid by members. Now, that some of this doesn't mean that committees could not do some preparatory work, right? Could do some of the initial upfront investigation on any of those things and bring it to the board. But what essentially that's saying is that only the board, right, as a whole can make those decisions. Okay. With respect to an audit committee, is if you have an audit committee, the majority of the committee must not be officers or employees of the organization or any of the organization's affiliates. So you need to think about if your audit committee is 3 people, that you probably want, you might have 2 directors or somebody appointed externally, and perhaps an employee. They just can't make up the majority of that audit committee. I think we're pretty close to, oh, no, we're not. We have more things that other areas that your bylaws need to address. You need to state when your organization's fiscal year ends. I think some of this is pretty straightforward and pretty obvious that you'll know. With respect to auditors, so ONCA provides the rules about duties of auditors. You can restate those in your bylaws, but you can't contradict them. And unless the bylaws state otherwise, auditors are allowed to state the reason for resigning or opposing their removal. And your bylaws need to say where your registered office is. Your head office comes into effect. Your head office, when ONCA comes into effect, that's your registered office. You do not need to state the location, right? So it happens when you, usually when you file your articles, you need to state your registered office, and that is the recognized office of the organization. So the only, I'm going to say the only, as I'm saying this, is the only reason that you might put things in your bylaws that are also in the act is that it forces you to stay current. So if the act changes, your bylaws need to change. And it is a way of ensuring that you're paying attention to those changes, but it just depends. We have a singing authority, not usually, but we might have a signing authority, is that your bylaws need to state which directors or officers are authorized to sign contracts on behalf of the organization, and the proper procedure for entering into contracts. You need to, you can state if your organization has a seal, what it consists of, not required, right? Your bylaws can state that the board has banking authority. It's not necessary because, once again, it's the fallback provision, and ONCA is a board. ONCA gives the board authority to make banking arrangements. But once again, it happens sometimes in member organizations that members don't read the act, but they'll read your bylaws or be familiar with your bylaws. So it may be that what you're doing in some ways is providing sort of member education so that they know, right, that is there. Or you can state that the board has the authority to make banking arrangements as provided for in the Ontario Not-for-Profit Corporations Act. Right? So just ways of once again, sort of double checking, going like, oh yeah, this isn't our bylaw. We can change this bylaw, but we cannot contradict it. We cannot contradict the act, or it's a way of educating that, yeah, this is in fact part of the act, and we're just acting consistently with that. Once again, unless your bylaws state otherwise, directors can borrow money, pledge debt, give guarantee, mortgage property, without the authorization of your members, right? And can delegate these authorities to a director, a committee of directors, or an officer, right? So if you're wanting to limit some of that or restrict some of that, you may want to make sure your bylaws address that. Again, with records and books and records, you don't need to restate the rules that ONCA provides. Some of that we've talked about with members having access to books and financial statements. But okay, and then bylaw amendments. So this is also useful. It used to be that you could only approve bylaw amendments at annual meetings, which got to be kind of awkward and inconvenient sometimes. But what unless you say otherwise, right? Unless your articles or bylaws have put this off limits to the board, directors can make, amend, or appeal bylaws or repeal bylaws, except bylaws about membership transfers, transfer of property and dissolution, or methods of voting remotely by members, right? So this is a bit of protecting members' rights. But the bylaw a bylaw amendment or appeal is effective immediately. If it's approved by the board, it's effective immediately, but it must be confirmed by the members at the next board meeting. So what that does is allow you to make those changes, but it also gives members the right to perhaps reject the changes that you've made. And voting members can also bring a proposal to change bylaws in the same way that they could request a meeting. They can request a meeting and bring a proposal to change bylaws if they so choose. Okay. So this is just, I think we've covered some of that bylaw amendment. So bylaw amendments or repeals are effective, but must be confirmed by members at the next meeting. Oh, I know what I did. Sorry. Thought the writing was too small on the other one, so I made it bigger and duplicated it. So bylaws may explain sort of the interpretation may explain that the singular includes the plural, vice versa, and or that references to persons includes firms or corporations, or sometimes that, pronouns, pronouns that are used apply to all, pronouns. So that's pretty commonplace. You don't always need to do that, but I think that's sometimes useful. And I think, yes, all right. So we're going to close out with just references. What I said to Megan at the beginning of this when I was doing this is there are some very excellent references that you can use. So these are the references that I used in preparing this. But if you go to nonprofitlaw.clio.on.ca, there are excellent articles that explain. One is what ONCA is, but it also gives you some side-by-side comparisons of check for this in your bylaws. Do they say this? How to construct your bylaws? And I think they're, the workbook is excellent. So it gives you a lot of very useful information and very free information, which I think is always, helpful when you're approaching this. Is that and I love lawyers like everybody else, but I think the more work you can do for yourself and leave less work, for legal review, probably the better. But you can do a lot of your own work with bylaws. They're not really not so much a mystery as we used to think of them as. Okay, and that concludes that. I do apologize for the typos in there. I will fix them. Yeah. Okay, let me just stop sharing. How are we doing? Oh, look at this. You have extra time in your day.
I was gonna say, you motored through that.
Uh-huh.
It's a lot of content,
Mhm.
content to cover. I do have a question here.
Okay,
So the understanding is that bylaws need to be updated by October
October
this year.
21st of this year.
October
Yes.
21st, 2024, to adhere to all of these new changes that are coming through.
Yes.
So if an organization has a bylaw document, can they update their own document, or is it recommended that organizations use the ONCA bylaw template that's available?
I mean, I think I would look at, depends a little bit on how long ago your bylaws were updated. I mean, if you keep your bylaws relatively current, I'd probably look at them and go like, is there anything that contradicts? Yes, thank you for this note here, is that articles need to be updated and submitted to the Ontario Registry Office as well. So you need to look at your articles, you need to update them, and you need to look at your bylaws. But, unless your bylaws you wrote them in 1960 or something and you haven't looked at them since. Okay,
Well, people are more up to date.
Yeah, but I think you can look at them and go like, okay, is there anything in here that's contradictory, and can we change that, right? I think that's what I'm seeing most people doing is not, overall, doing an overhaul, but so much of it is my favorite answer. It depends, right?
It depends on the organization and what you already have in place.
Yeah, and what you already have in place, the kind of capacity that you've got, and etc.
So we have another question. Is there any requirement for a code of conduct under the act?
No, no, you do need, I mean, you do need to ensure that your conflict of interest provisions are there, but it doesn't say anything about having a code of conduct. My personal opinion is, I think all boards should have a code of conduct. And it should be really clear, and it might restate some of the things that are in your bylaws around, conflict of interest, etc. But I think just, the requirements for being prepared, the requirements for, the expectations of the board, that you act in good faith, that you're really acting as a servant leader on behalf of whomever you're governing on behalf of. So I think it's really helpful to state that.
And then we do have a question about articles and where they could find them, but I'm assuming that is something that's based on the organization. Is there a way that someone could publicly look up the articles?
Yes, so another very helpful comment in the chat, or so articles need to be updated and submitted to the Ontario Registry Office. Apply for your Service Ontario company key now, and you will need it when you file. So I think if you keep the chat notes anyway. I think some of those chat notes are really, really helpful.
Perfect. And would a copy of their articles be on the Service Ontario company registry?
I don't know. So another note here. February 29th, Valley Heartland CFDC will have a Clio representative on site for a full day workshop. So that's fabulous. Yeah. Like I said, they're really excellent. And there is a Ontario.com registry. So there is a link in here. So I think if the notes go out, for people, there are some really, really helpful information on here.
Absolutely.
People who should have been giving this webinar. Yeah.
Yeah, there you go.
Yes, so thank you for those very helpful additional comments. That's a lot of really good stuff in the chat.
Yeah, I was gonna say it's some good stuff. It's been something on people's minds about getting things updated, which is good because it has to be done this year.
Yep. And the more you hear it, the more helpful that is, right? So
absolutely. And it makes it easier for people who may not have started the process. So here's all these resources that are already available. Now, I don't see anything else in the Q&A box, and I don't see anything else in the webinar chat. So if anyone has any follow-up questions after this, please feel free to forward them to myself or Rose. Be happy to answer some questions for you. As I mentioned, there will be a email going out that'll have a copy of this recording. I will include the chat notes.
Okay, and I will edit the
Rose is going to send us an updated version of the PowerPoint. It's going to be included also in the email, as well as that 2-minute survey. If you can get a chance to fill that in, that would be really appreciated. And Tina has put in some other excellent workshops that are coming up, that if you want a little bit more hands-on stuff, there's some things coming in there. But yeah, so if anyone has any follow-up, please feel free to email us. We can give people their extra half hour back right before lunch.
Yeah, I know. That's great.
Yeah, so thank you so much, Rose, for coming.
You're welcome. It's my pleasure.
I know it's a bit of a bear when it comes to content, but we appreciate you putting it together and spending some time with us this morning.
Okay. All right. Thank you. It was a pleasure.
All right. Thank you, everyone. Enjoy the rest of your day. We'll follow up with an email, but thank you for joining us, and we'll see you next time.